Under India's Digital Personal Data Protection Act 2023, consent has transitioned from a user interface element to a strict legal instrument. If this initial interaction fails to meet statutory standards, every subsequent data processing activity lacks a valid legal basis. Internal compliance strategies often stop at the privacy policy, but the DPDP Act measures validity through the technical execution of the data flow, not the text of a legal disclaimer. This creates a friction point. Existing data collection systems were rarely built to meet these specific tests, making many current consent flows architecturally invalid. Treating user consent as a front-end design task rather than a back-end engineering requirement leads to foundational legal failures. This comparative schematic shows the divide. On the left, the legacy architecture, defined by pre-ticked boxes and scrolling text, creates a tangled data bundle hitting a processing bottleneck. On the right, the dynamic, modular toggles required today. The DPDP Act prohibits holding primary service delivery hostage in exchange for secondary, unrelated data permissions. Relying on forced conditions of service is an explicit statutory violation rather than a valid collection method. Maintaining legacy IT Act infrastructure means operating outside the bounds of India's current data protection regime. Section 6 of the DPDP Act dictates that valid consent must pass 5 measurable tests. First, it must be free, offering the data principal a genuine choice without coercion. Second, it must be specific, tied to a defined purpose rather than an overly broad approval. Third, it must be informed. Fourth, it must be unconditional. And fifth, it must be unambiguous, requiring a clear affirmative action instead of user silence, inactivity, or pre-checked boxes. Under Section 5, a structured notice must legally precede the consent request, clearly outlining the data, purpose, user rights, and grievance mechanisms. Crucially, this notice cannot default to English. The user possesses the right to choose any language listed in the Constitution's 8th Schedule. Failing even one of these 5 tests, or omitting any structural part of the notice, nullifies the legal validity of the consent. Sections 6.4 through 6.6 introduce the statutory right to withdraw consent. This establishes the rule of symmetric friction. The operational difficulty of withdrawing consent must exactly equal the ease of granting it. Once withdrawal is initiated, both the data fiduciary and any data processors acting on its behalf must cease processing operations. The right to withdrawal is absolute, though the functional consequences of losing that data processing are borne by the data principal. High-friction withdrawal flows, like requiring email support tickets, now represent a legal liability. The DPDP Act also introduces a new legal entity to the ecosystem, the consent manager. Under this model, data fiduciaries no longer hold exclusive control over the user consent interface. This federated architecture functions as a single, interoperable platform where data principals can review and manage permissions across multiple services. Consent managers are registered with the Data Protection Board and answer strictly to the data principal, not to the enterprise. Architecting back-end interoperability with these third-party managers is a looming requirement for all data fiduciaries. Moving from statutory theory to application requires diagnosing failures in standard business operations. In e-commerce, tying marketing permissions to checkout creates a compliance failure. While checkout is a legitimate use, making it contingent on marketing fails the unconditional test. They must be decoupled. Similarly, in healthcare, using blanket treatment consent to share records with research partners is flawed. This data flow fails the specificity test. Research data sharing requires targeted permission, independent of the original treatment agreement. In banking, systems often conflate statutory anti-money laundering and KYC processing with internal profiling. The statutory basis protects the initial KYC process. However, secondary profiling mandates an entirely separate, informed consent step. Finally, consider a loyalty program that bundles enrollment with third-party sharing. This fails the granularity requirement. Each purpose demands a distinct action. These optimized user flows are structural compliance failures requiring immediate re-engineering. With these failures diagnosed, organizations must execute a precise engineering roadmap for DPDP enforcement. Priorities 1 and 2 require establishing a granular consent architecture that avoids bundling and deploying plain language regional notices. Priority 3 directs engineering teams to build symmetric withdrawal mechanisms that match the friction profile of the original consent flow. Priority 4 requires immutable consent receipts and audit trails. Systems must track notice versions, chosen languages, and exact timestamps for every transaction. Priority 5 mandates just-in-time consent, requesting permissions strictly at the moment the data is needed, rather than upfront. Priority 6 dictates that organizations prepare internal enterprise systems for interoperability with registered consent managers. Surviving a regulatory audit will depend on the strength and immutability of this specific engineering architecture. Operationalizing DPDP-compliant consent is operationally impossible if siloed exclusively within the legal department. It requires coordinated execution across product design, software engineering, and enterprise security teams. At Second Quadrant Consulting Solutions, we design these compliance frameworks, draft precise notices, and build the back-end audit infrastructure required for enforcement. We invite enterprise leaders to schedule a DPDP readiness assessment to stress test their current architecture against the mandates of the new Act. A robust, auditable privacy architecture represents the only viable pathway for continuing data operations under the DPDP Act.